Welcome to the Exhibit A podcast.
We are on. Today, our conversation is going to be something that's a little more intellectual than what we've had in the past. I couldn't help but bring in the two Monets with us today to help me with this discussion. First of all, let me reintroduce Monet H. She's with us. Hi, Monet. Hello.
Hi, Don. Good afternoon.
Okay. And we have Monet K. She's with us. Hi, Monet.
Hi, guys.
So in our law office, we have the good fortune of having two Monets that are brilliant. They're both excellent attorneys. The only problem that we have with the two of them is distinguishing them by name. So for your benefit, I'm going to refer to them as Monet H and Monet K, because that's how we speak of them around here, but they actually do have full last names. But I promise you, we'll try not to make this too confusing. So what we're going to talk about today is a very interesting topic, and that is, are we in a no-fault state? Is California really a no-fault state like we claim it is? You know, people come to us all the time and say, you know what, he was cheating on me, and for that reason, I should get extra money, or I should be paid extra spousal support, or, he was, just a bad person throughout our marriage, and don't I get, more because of that? Well, in the old days, I presume that those things were factored in as to the division of property and maybe some other issues. But when I was a kid, I remember distinctly in Illinois reading the newspaper and there being a headline that California became a no-fault state. It was one of the first states, to my recollection, that did so. So first of all, Monet K, what is a no-fault state to you? What does that mean?
A no-fault state just means if you want a divorce, you get a divorce. You don't have to really prove anything other than, hey, I want a divorce, we don't get along anymore, which is why, you check off the box in California that says you're getting a divorce because of irreconcilable differences. Fancy way of saying we don't get along anymore. So to my understanding, that's a no-fault state. Okay.
And Monet H, you probably are aware of the fact that there's still a small number of states that are fault states. I think most of the states are no fault. But if you were in a fault state, have you ever heard of the term mental cruelty?
I actually wasn't aware that there are a couple of states who are still fault states. I do get a lot of clients who ask me that, and he cheated on me, so can I get, can that be used to my advantage? And, so I know that people are still confused. I wasn't aware that some states actually still follow that. And to answer your question, yes, I am aware of that term mental cruelty, and I'm sure it's been used a lot by, both men and women and trying to gain an advantage in their divorce.
Yeah, let me say this. I'm not positive that there's other states that are, probably should do some research on that. But I do know that there's some states that still take into consideration whether or not there was infidelity as it relates to things like paying spousal support and stuff. So we know that there's other countries certainly that are still fault states. So what it was is back in the old days, you didn't get your divorce unless you proved that you had grounds for a divorce, and we joke a lot of times, look, I'm going to divorce you because you're being so mean to me tonight, mental cruelty. I hear that a lot among my family members, and they always turn to me and say, Don, what do you think? And I jokingly say, yeah, you're right. But realistically, California has been a no-fault state for a long, long time. And so the question is are we really? And what I want to do is talk to you ladies about a couple of case decisions that came out. One of them is marriage of Nat Carney. The other one is marriage of Menjivar. They're not brand new cases, but they've been around for the past 10 years. Let's say they were published, and they've impacted the way things are being played out in family court. So let me start off with Monet K. Since you've researched these cases, tell us about what Nat Carney says.
So Nat Carney is an interesting case, and I think it's kind of fruitful to take a look at the background just a little bit. So here the husband hacked into the wife's email address and found several emails about where the children were going to be, custody arrangements, and some of her emails were emails to her financial people, her attorneys and such. So she alleged abuse based on that. This is abuse and this is a disturbance of my peace. And so the Nat Carney court had to really flesh out what abuse meant in this situation and what really disturbance of the peace meant. So they looked at a construction of that word. What is it to mean to disturb the peace? And they said it's disturb means to destroy, and peace is freedom from anxiety. So any conduct that destroys the mental or emotional calm of the other party is disturbance of your peace. And it's part of the DVPA. It's in congruence with the DVPA, which is the Domestic Violence Prevention Act.
Okay. And so my recollection of Nat Carney, I haven't read it in a while, is that these people were actually separated, if not divorced. There was a custody issue. Mom had claimed that she was one place where in fact she was the other. And what happened is the husband broke into her email, or ex-husband broke into the email and was able to prove that she was, I believe, in India rather than the United States, or something to that effect, and attached it. Is that, am I close?
Yeah, you're absolutely right. He basically was told, mom told dad, I'm going to be here in this location, and the brother is babysitting, my brother is babysitting the kids, taking care of the kids. He then found out that the kids kind of told him, that's not really true, or being evasive with the answers. So he then argued, I didn't really hack into her email. I knew the password. I'm the one who actually created the account. But the court didn't really go into that. The court really spent the time talking about what is disturbance of the peace, because the husband was alleging this is not domestic violence. This does not disturb peace. It's not part of the code. It's not, within the meaning of the DVPA.
Right.
So important decision here.
But the parties were, though, clearly separated, not divorced. And so he had no business looking into her email, right? It was kind of an invasion of privacy decision. And that's where, when we received that decision, we thought, oh, okay, well, that makes sense. I mean, people shouldn't be breaking into each other's emails when they're separated, right? They're not living together. I mean, they're violating each other's rights, kind of. And what he did is, he wasn't the brightest guy. He attached her email to his declaration as an exhibit to show his point, to prove his point, right? And then she used it against him to get the restraining order, right? Okay.
Yeah.
All right. And then we have the case of Marriage of Menjivar. Tell me about that case.
Marriage of Menjivar, actually, this is a little bit sad. So the girlfriend was beaten up pretty bad by her boyfriend, and she tried to escape the relationship. He was controlling, hey, I'll change. She came back. In the midst of all of that, she gets pregnant. He's still beating her, hitting her. The mom is a witness to this. She wanted to take community college classes. He enrolled in 5 of the 6 of her classes, and then kept repeatedly texting her throughout the time that she was in the other class he wasn't enrolled in. So she went and she got a restraining order. She filed for one. And the trial court said during the hearing for the permanent restraining order, well, he hasn't abused you in 6 months. So there really is no abuse. He moved from his house. You guys live farther apart, so there's no abuse. And the appeals court said, well, no, we don't look at what happens in the future or the likelihood of abuse in the future. We judge these cases based on what happened in the past, and there was substantial abuse. The trial court actually said there was substantial abuse that has happened in this case, and still denied her domestic violence restraining order. And the appeals court just struck that down and said, no, you don't look at the future, you look at what has happened.
Okay. And let's talk a little bit about these facts, because this was really interesting. So the young lady and the man were not married. Am I correct?
Yeah, I believe so.
There's a boyfriend-girlfriend situation. And from what I understand is, besides beating her a lot, that he was very jealous and controlling, correct?
Correct.
Okay. And in my reading of the case, again, it's been a while, is that she was attending my favorite college, Pasadena City College. And while she was there, he would make her keep her cell phone open so he could listen in to see if she was talking to other men. Am I correct?
Correct. He was very controlling. He didn't really have her have any relationships outside of their relationship, and in addition to the physical abuse that she took from him.
Yeah, and one of the classes he enrolled so he could sit right next to her because he was so jealous and afraid that she would do something that he wasn't comfortable with. So he's really trying to control her. And the Menjivar case really, to me, as it applies to our topic today, is it brings in the notion that the trial court has to consider controlling behavior. And that's mental abuse because, again, going back to Nat Carney, it disturbs one's peace, it causes anxiety, and when they rise it to a sufficient level, it's enough to get a restraining order. Am I right so far?
Correct, absolutely.
Okay, so let me turn to Monte H. Now, we know that there's a lot of behavior in family court that is directly influenced by appellate court decisions. Once these cases come through, just like any other area of law, we start seeing permutations and the law developing. What have you seen as a result of these two cases as far as how people are trying their cases now?
That's absolutely correct, Don. I've seen, obviously in a case where the controlling behavior and the mental abuse is so strong, where someone is taking classes, spying on your phone, controlling who you're friends with, restricting your access to your friends and family, of course, I think that warrants a restraining order. But I think what this case has done is obviously expand the definition of a domestic violence, of what constitutes domestic violence. And it's, in a way, it's had a negative impact on, the system in regards to people following frivolous domestic violence cases. And it's also kind of taken us back to re-examine the question of, are we really a no-fault state, as you mentioned in the beginning? Because just recently, you and I were involved in a hearing, a domestic violence restraining order hearing that lasted a couple of days, where, the husband and wife had a very, specific way of communicating with each other. They used a lot of vulgarity on both ends of the marriage. They cursed at each other, they texted each other nasty messages. And this was just how they were. It was their relationship, and, it worked for them. It was both ways. And unfortunately, one of the parties documented this and the other party didn't. And the party who documented this, text messages of the husband, sending nasty things to the wife, she was able to get a restraining order, not because there was any physical violence, any threats of physical violence, or even any controlling behavior necessarily, but because, that disturbed her peace, even though that was the norm in their marriage, and that's how they communicated with one another. So I think, in extreme cases where the behavior is controlling, it does lead to isolation and financial abuse and things of that nature. I think, of course, it's good precedent, but I think when people start relying on it for the wrong reasons and start filing these frivolous restraining orders, and I think that's kind of where it's headed, and that could be dangerous to people who are actual victims and who do actually deserve to get restraining orders against the abusers.
Yeah, so what we're seeing is at the beginning of a lot of cases now, even before a divorce is filed, there's a request for a restraining order based upon quote unquote controlling behavior. And it seems that the trial courts are accepting evidence of nastiness during the marriage. Monte K, you might think that, I'm not the greatest boss in the world, and I might, say some things around the office. I might swear. Maybe I do swear a little bit and stuff.
You've never done that.
You've never heard me swear. Okay, good. I'm doing well, I guess. But it's kind of like a marriage, people fight, they argue, they call each other names, they intend to hurt each other when they call names. They don't necessarily play nice when they argue. Monte K, do you know what I'm talking about? People do that in their marriages.
Yeah, they do. And I think what Monte H was kind of bringing up in your guys' matter that you were in court with is it's interesting, right? Like, if the dynamic of the marriage is such that both of them talk to each other the same way with vulgarities or with profanities, and that's their style of communicating, we could debate whether that's healthy or not, but that's really not the issue here. The issue is that domestic violence if both people are doing it. And, and one person just happens to document it. And so when a court comes out with a decision like that, I'm wondering how that affects other cases, if that somehow impacts others to document every little text message and to document every voicemail. Are we doing divorce planning now? Like, it just opens the gates to a lot of questions, making it very difficult for attorneys, because as we know, sometimes our clients don't have the one document that we need them to have to defend them. So it's an interesting turn of events.
Yeah, and Monty H, so what are some of the consequences that come as a result of people now being able to go into court and say and get a restraining order based on emotional abuse? We're not talking about domestic violence. We're not talking about threats. I'm talking about nasty messages, text messages where, you guys calling his wife a bunch of names, over a 6-month period. What are the potential consequences of that if the wife prevails in court?
The consequences, Don, are very detrimental to the person who loses the restraining order, because that could affect their livelihood. It could affect their career. It could cause them to lose their license. It could, and most importantly, it'll affect the time they have with their kids, because depending on the length of the restraining order, as you know, there is a presumption that against the party who has the restraining order that, they can't have joint custody of the children until they overcome that presumption. So, whether it's 1 year, 3 year, 5 year restraining order, that definitely affects the custody arrangement, the amount of time that a parent has with the children based on, some nasty text messages is unfair. It's, not only financially, but most importantly, it affects the relationship you have with your kids. And, I think that's terrible. And I think that we're starting to really see a pattern here of people preemptively filing divorce planning, applying for these restraining orders that are unfortunately being granted when, there's really no real evidence of any sort of physical or mental or any controlling behavior. So I think at the end, it's the kids who are really affected by it. And I think that's definitely was not the purpose behind the case law, and that wasn't the purpose of the legislator when it enacted the act. So I think that's really unfortunate.
Yeah. I had a case not too long ago where my client, a male client, was physically accosted by his wife, his mother-in-law, and his father-in-law. And the evidence was on video. It actually showed the man being choked, strangled by all three of these people. And the defense was that he was engaged in controlling behavior throughout the marriage. So therefore, there was, it was kind of like what they did was okay because he was being obnoxious. He wouldn't give back a cell phone, and so he kind of deserved it because he was controlling. And the trial court denied his restraining order because of the allegation of controlling behavior. So, I see this as going both ways, people using it as a defense as well as offensively. Monty K, can you think of any other consequences where somebody gets a finding of domestic abuse that could impact the divorce at the very beginning of the case?
Yeah, I mean, Monty H brought up, obviously, custody is a huge one. It stays with you for a little bit, even when judges say, well, I'm only granting it for a year and it's very loose. We have seen the effects of that, because then the other parent just, every single pleading is there's been domestic violence in this case. But another is spousal support. And Don, you and I did a podcast on this a couple of weeks ago where basically the husband had committed, or the wife alleged that the husband had done domestic violence in the past, but what she had done was put snakes and rats in the husband's home. The husband went and got a TRO and then got a restraining order. There was a criminal restraining order, and then came spousal support, and she was like, I want spousal support. And so the presumption is against you, right? You're the perpetrator of domestic violence. Why should the victim give you support? And she said, well, no, I'm a victim too. He's, yanked my arm, he's bruised me, he's dragged me across the floor. And the court said, okay, where's your evidence for that? And so the appeals decided that in those situations, when you're trying to rebut the presumption against you in spousal support situations, you have to have written documentation of that evidence. And I remember doing the podcast and you and I discussing, how are you going to get that in the midst of violence if you're being dragged across the floor, or if you get your finger yanked out? Is an x-ray enough? Is pictures enough? So that's also another area that domestic violence, really, that restraining order carries over.
Yeah. So without a doubt, if there's a finding of domestic abuse or domestic violence, and we say abuse now because we know from from Nat Carney and Menjivar that it doesn't have to be violence at all, that the court has to take into consideration if there's a finding, whether or not there should be a payment of spousal support. If the perpetrator is committing domestic abuse, Monte H, and the perpetrator is a housewife that they've been married for 30 years, no violence, no threats of violence, but she's a nagger. She's somebody that's like, calling him names as he's leaving for work, and he comes back to work and she's, screaming at him because, he came home late, and calling him names and maybe sending some text messages. And the court finds that happened. Isn't that something the court has to consider in ordering whether or not, or deciding whether or not he has to pay the spousal support to her?
I absolutely think that's something that should be considered, given the history of case law and what we just discussed. I think, unfortunately, a lot depends on, who your judge is and what courtroom you're in, and I guess how bad those text messages are.
Yeah, 30 years, Monte K. This woman raised his kids.
Yeah.
She was the one that took care of all the household responsibilities for 30 years. And in this hypothetical case, she's even, sacrificed her own career because she wanted him to go out and slay dragons and make something for the family. But she was a nagger. She was somebody that was constantly calling him names and stuff. And he's got the text messages to prove it. Is that really how we want to solve these cases, by saying you can't receive spousal support because you've been screaming at him for 30 years?
Yeah, so I just a little tidbit on spousal support. They're like my favorite cases to litigate ever. So spousal support has a lot of factors when we look at it. And one of them is that how much you've worked, who was the primary custodian, who was in charge of the household chores, who went out and had the job, who had to sacrifice for what. Maybe she helped him get through a school, a trade school, or a graduate program. What are her responsibilities? What are his? And part of that is any evidence of domestic violence and any conviction of domestic violence. So
abuse.
I'm sorry. So you have to consider both. So in that situation, I really think that it really depends what the text messages are. And I think Monte H is totally right. It depends on your judge. One thing to consider in family law matters is some of your clients don't have enough money to go on appeal. So really, that's why sometimes these cases don't get really flushed out and there's not a lot of explanation, because things change at the trial level that are not necessarily reflected on the appellate level always, because, if your clients spend a lot of money doing the divorce and fighting the domestic violence, they might not have enough, unfortunately, to take the matter on appeal. But in that particular scenario, I hate to say it, it depends. A part of me says, in any situation when someone is really manipulative and they're texting you constantly and cursing at you constantly and maybe manipulating you to do something you don't want to do, we definitely want to see where we could get domestic violence on that. But if she's nagging and maybe she says a word here and there, I'm not too sure if there's evidence strong enough for domestic violence. But this is the land we're in right now.
Okay, so on to you, Monte H. I'm gonna stop resisting, okay, the law here, okay? I'm gonna accept. I'm gonna surrender, man. We're in this new world, okay? And now you've got a client that comes to you and wants to assert that he or she is the victim of domestic abuse, right? All my marriage, man, it's been horrible. I'm mentally, hurt. I've got some inabilities to even work now because of all the stuff that this person has been saying, and in the names and all that stuff. So what kind of evidence are you going to tell that client to gather so that you can make your case? What are you going to do?
I think, the first thing would be to have some corroborating evidence of text messages. If you have any witnesses that might have been there during these incidents, other than your own testimony, I feel like it's difficult to kind of, get corroborating evidence on things that really are like personal to you and your feelings and your state of mind. And, but I've seen the cases where people are successful in getting restraining orders based on these things are those who have, keep a record of these things. And a lot of people aren't doing that during their marriage, unless you're pre-planning for something, you're not going to have like a record of every single thing someone sent you, or, you're not going to be recording conversations. And if you are doing that, then obviously your reasons for wanting a restraining order are, they're not for the right reasons. So
I would say you should bring in recordings of any messages left, because you're not, specifically recording. They're leaving messages on your phone, any emails, text messages, witnesses, like you said, right? Things like that, I guess. So Mane K, we talk to people about, getting into signing premarital agreements, kind of saving things, like your records, making sure that there's no commingling and keeping your separate assets separate. Are we also now going to talk about, why don't we just throw in some extra advice that, keep all your text messages and your emails along the way? And is that something you're going to tell your clients?
Yeah, honestly. I mean, really though, we have a lot of cases where they just go, oh, it's been deleted. I don't have it. I changed phones. I changed hard drives. And then, pretty much you have no evidence to attach to your declaration. And it's a he said, she said, or they said rather world. So I would go further than that. I would say don't grab each other's phones. We're seeing a lot of domestic abuse cases based off of phone grabbing, because it's property. You're grabbing somebody's property. And I think that in the midst of it, if you're this couple and you're arguing, you don't have the law in the back of your mind that's, clicking, and you're like, don't do that. So the other advice is don't grab each other's phones. Don't do it. Don't grab laptops. There's a lot of DV cases now about phones and laptops. Okay. And so keep everything and don't grab phones.
Right. I agree with that. We've seen a lot of the phone grabbing incidents. So Mane H, we just had a very thorough discussion about what's the world like now, in light of Ned Carney and Menjivar. Are we in a no-fault state?
I think, as far as wanting a divorce, technically we are, but I definitely think that we're kind of backtracking here in terms of how far we've come, because we're now seeing these cases where people are getting restraining orders to gain a tactical advantage over spousal support, child custody, and they're using, these text messages, these things that were fine during the marriage for 8, 9, 10 years, and that's just the way you communicated. And now they're, trying to use it against the other spouse by presenting this as evidence and saying, he or she was controlling me. And, we really need to examine, like, what is control in the context of this relationship of when two parties are married? Is it controlling to tell your wife how she should be saving her money instead of going on shopping sprees? Is it controlling to want some space between, like, your family and, your in-laws? Is that controlling? Is does that mean you're keeping your wife or husband away from their family? You know, looking at like the wheel of control and looking at case law, I think we're really starting to get into some like dangerous territory where we're losing that line between, you know, what people do that's personal to their marriage and, you know, what is considered actual abuse, whether that's physical or, you know, emotional or mental abuse, which does happen a lot, but is that what's happening, or are people just doing it to gain an advantage?
Yeah, you know, you could always divorce them, right? Doesn't necessarily mean you have to throw mud at them just to get what you want in family court. You know, so the whole point, Monte K, of no fault state was to avoid a lot of litigation. I mean, I was just a young boy when California became a no fault state. But when you talk to the old timers, and there's still a couple of them around that practiced during those years, there would be days talking about, you know, trying to catch somebody doing something wrong, private investigators crawling around, looking through windows and all that stuff. And it was very long and messy trials. Are we back to that now? You know, are we dissecting marriages now and looking at the conduct of the parties?
Yeah, I think that what's happening now is really a disservice to really the drafting of the DVPA, the Domestic Violence Prevention Act. And it's really a disservice to all of the women and men that have been abused in extreme measures, such as manipulation and mental abuse and emotional abuse, physical abuse in the past, that have come in and gotten their restraining orders. You know, if the court is trying to kind of make a ruling, you know, or make a decision to say you cannot, you know, use profanities in your marriage, that's a bigger conversation of whether the court has jurisdiction to do that, whether we should be doing that, whether we're inserting some sort of morale into society by these rulings. I mean, it's really, you know, you're really thinning at something that was written for a very serious action for, you know, violence and abuse in marriage or in a relationship. And now if we're going to go as far as to say, well, it also includes controlling behavior, we really need to articulately and clearly define what that means. Because as Monte H said, potentially if I say, hey, you know, husband, I don't want to, you know, see your sister this weekend, or I don't want the kids over this weekend. And he goes, oh, she's controlling me. And then boom, I don't get to see my kids in my marriage because I was feeling whatever way on 1 or 2 days. So is that really a service to victims of domestic abuse and violence? I mean, that's really the question I'm having.
Yeah. Well, this has been a fascinating discussion. I think that, you know, we flushed it out. There's no easy answers for these things, obviously. I mean, we want to protect victims of domestic violence and domestic abuse, but at the same time, we want to make sure that we're not trampling over people's rights and hurting, you know, otherwise innocent people for engaging in being a nasty spouse during their marriages, but without abuse. So thank you very much, Monte H. It was a pleasure having you back on.
Thank you, Don. Likewise.
And Monte K, once again, thank you for joining us.
Thank you.
Okay. And thank you for joining Exhibit A. We'll see you next time.